Hi, Daniel.
How are you doing?
I'm good, thank you. How are you?
Very good. Thank you so much. Thanks for joining.
Yeah, thanks for having me. I'm just gonna
Yeah, I
put a
think it's
coffee.
going to be an awesome discussion. We're starting our day in South Africa. I know that you're at the end of
Oh,
your day that side.
yes, we are finishing up.
Yeah, so I know it's your first live.
It
It's
is.
also our first time doing a live outside of South Africa, so we're so grateful for the opportunity to speak to you. As I mentioned, we've been following your journey as well for quite some time now. And you often inspire us on the other side of the world with just the way that you
Good.
conduct yourself, the way that you treat people. I think with the state administration, the care that someone has for family adds so much value to the administration process. So I know that your clients are in good hands.
Oh, thank you, and
Um,
likewise.
Thanks. I just wanted to give us a brief introduction, and then we can get started. Morning, everyone. My name's Daniel Marsh. I'm the founder and director of Marsh Fidelity, a specialist wills and estate business based in Durban, in South Africa. Lovely coastal area in our country. I'm joined by Angela from AJT Legal. Angela is a specialist in estate planning, law, in estate administration, and conveyancing. She has been running up a practice. I think it's out of Gympie.
That's right.
Yeah,
Gympie in
yeah.
sunny Queensland.
Awesome. And yeah, she's got a team of professionals. And I think where we align is that firstly, we both really invest in education and being qualified to actually do the job. And then secondly, we really have a humanitarian approach to the whole process. So I think in terms of my view, like I said, my grands recently immigrated to Australia. I know that there's a lot of people that own assets in Australia and South Africa, and due to the increase in mobility of people just generally, I think estate planning is going to become more of a global viewpoint. But when someone moves to Australia, I think it's also important to understand what the processes are in that country for estate planning, for wills. So Ange, if you don't mind just giving a bit of background to how you got to where you are today, and then some estate planning tips that you found have really helped your clients.
Sure. So where I got to today, I could give a really long part of that story, but I'll try and give it a
Yeah,
brief. So I certainly didn't have sort of a conventional path to becoming a lawyer.
yeah,
I finished high school not even qualifying to go to university. I had no idea what I wanted to do.
sure.
And then I just started, as a junior working in a law firm as a receptionist, and just grew to love the law and was
Yeah,
inspired by a mentor to apply to go to uni. So,
yeah,
the rest is history, I guess. So 6 years into owning my own practice now, and just really have loved being able to niche down into the areas that I really enjoy working in, and that's certainly estate admin and estate planning.
sure. And I think it's so important for people to keep in mind that um, in terms of like if you so like you said you hadn't qualified to get into university, but then you found something that you loved, and all of a
Yeah,
sudden you just excel at it. So you never know when that time will come, just as long as you keep showing up and keep doing your best each day. And that's also
absolutely.
what I love about the work that we do. You can actually see the impact of applied law in families. Like there's such an opportunity to release burdens from families if they've got a good professional on their side. I know
Yeah,
I see quite a lot of posts on your side about post office wills. In
yes,
South Africa, we've got a company that basically sells pre-written wills, which people also just go and buy and fill out.
yeah,
But the problem with those wills as well is they're so general that someone that might have a unique family situation does that will after they die, there's a massive mess.
that's
So I think
right.
consulting with a professional is always like it's the first thing that you should do, especially if you have young kids or if you've got an elderly parent that needs care for, unique situations like that.
Absolutely. I kind of liken it to an analogy I like is, I can go to the auto shop and buy an oil filter for my car, and it will have some instructions on the back on how to install that in my car.
Yes.
I can read the instructions and I can do that. I think I've probably done a good job.
Yeah.
I'll drive my car down the road and it will break down because I actually didn't do it very
Yeah.
well. if you apply that to a will kit, like what you're talking about in South Africa and what we have at the post office in Australia or online will providers, you might think you've done a good job, but you won't know it's broken, unfortunately, until it's far too late. So, you won't be able to fix it. So
exactly, and also remember, like what I've found with wills and estate planning, it's not I sign my will, I'm done. If you have a relationship with the administrator, it's a yearly thing. Life changes. We have kids. We lose people we love. We buy homes. Now, if you've got a will kit, who are you consulting with? Because you've signed your will now. Then you see, as your life evolves, you need to evolve with your planner. And for a family to have a link to a planner when they die, it's the peace of mind to loved ones that are there, and they say, "Oh, I know, and this is her office. We've been dealing with her for years." That the amount of relief in a family's hearts is like, you can't even explain that sort of level of relief.
Absolutely, yeah. And like you've touched on, a will is just, it can never be a set and forget document. It's going to suit your life at the moment. And hopefully it will suit your life for some time. But if anything changes, like you've said, having more children, losing people, buying properties, financial situations changing, those documents need to be reviewed when things like that happen, and that's just not going to happen with a will kit.
So I think that's something which specialist businesses like ours differentiate, because in my view, so I always say, like, will planning is not only a financial plan, because everyone that I've consulted with that are close to death, they always say that their greatest assets are their loved ones.
Yes.
So will planning is actually relationship planning. If you can take care of your family through a will, you are actually being an act of service. It's not only the financial movements, because everyone's quick to say, "Hey, will kits is cheap. Where can we get discounts?" But those discounts may create a massive burden on loved ones. So if we can plan well for our relationships and have a professional that helps walk them through that process, that's where the will planning starts. And I think one of the things that you have put together, which I think is really cool, is that letter of wishes consult that you do. If you don't mind just walking through that service that you provide.
Yeah, absolutely. So this is our letter of wishes workbook. So it's basically an add-on to our estate planning documents. So the estate planning documents that we do are a legally binding documents. This is not meant to be a legally binding document, but I'll just give you a little flip through. You can see it's got all little prompts here to fill out. So this is important information that doesn't necessarily belong in a will or a power of attorney document. So just simple things like bank account numbers, who your lawyer is, who your accountant is, any funeral wishes you might have, just all things like that your family might not necessarily know. And if you don't have your paperwork in order, which a lot of us don't have everything all filed away in a lovely filing cabinet, that is the stuff that makes estates difficult to administer. And when things are difficult, it's not just difficult for us as lawyers to get it sorted, it's difficult emotionally for the family because it's the additional stress that they don't need, and it is avoidable. And I definitely enjoy dealing with estate admins where everything is just nice and written down and easy, and we can just get it sorted, and there's no additional stress for clients and family members.
I don't think I've ever seen a letter of wishes as detailed as your book that you've just showed me now. And one thing that I think your letter of wishes will really help towards is, which some people don't really consider, is how you can get closure through estate administration. Because when you've lost someone you love, yes, there's financial movements as well, but also to get closure, it helps. So having a will, it's the last written document basically that your family will have of yours, but also access to information. I mean, that provides such peace of mind to loved ones to say they actually really considered every process, and thank you for helping along the journey to get all of this done. And that's how you can get closer to closure, because some of the most heightened grief clients that we've dealt with, it's where there's no will, or they don't know what the client owned, they don't know what policies they had. This just helps so much. And I think that will also help in relationships where maybe one spouse doesn't really know exactly who the insurance is. Now, if you have a document like that, even if it's kept with you, you step into the shoes and say, don't worry, we've got it handled. We know this is where the insurance is with. We know the car was with this company. And I think that that really helps.
Yeah, absolutely. And, like you were just saying about, estates where there is no will and the fallout from
Yeah.
that, because if you don't have a will, the government has a plan for you. At least that's how it works in Australia.
Yes.
So your money will be going somewhere, whether you like it or not.
Yes.
And sometimes it's the fallout of that can be really devastating, because that money may be going somewhere where they definitely wouldn't have wanted it.
Yes.
And the rest of the family can often have a lot of difficulty in accepting that. And that's really very tragic.
Yeah, I mean, basically, it's similar principles apply in South Africa. But what happens is some families have dynamics where they're not all getting on well. Or say you might have a child who is abusing a substance, but they're over 18, so they can inherit. Now you don't have a will, and all of a sudden this child, which is meant to be protected from large financial gain, gets, say, 3 million rand deposited into their bank account because there's no will. You can see how detrimental that can be, and also to maybe they've got a surviving spouse. I think that if you don't have a will, it also opens up opportunity for people to fight, because there's no clear direction. This is what goes to that person. Now, all of a sudden, someone might come and say, hey, I'm coming in here and I want to take as much as I can. It just takes longer as well.
That's right. And everyone's perspectives will be different as to what should and shouldn't be happening there.
So I think just having a lot of people have all these wishes and dreams about their estate planning. I always say, let's have wishes and dreams, but make sure you have a will, and then you can wish and dream on top of the will.
Correct.
Because a lot of people say, hey, I want to put this in my will. They even write an email. So, I mean, in South Africa, the only way a will is accepted by the court is if it's originally wet ink signed.
Yes.
They don't accept digitally signed wills, and the same with property transfers in South Africa.
Yes.
So even if you send an email to someone to say, I want this in my will, and they receive a draft, if they haven't signed it, it's as if they never had a will.
Yeah.
So that's important as well,
yes.
to follow the legal requirements. And if you don't mind just giving what some of the key legal requirements are for valid will in Australia, and I just want to see if they align with the South African one.
Yeah, absolutely. So like you've said, a wet inked signed will is necessary. It needs to have 2 witnesses to that will.
Yeah.
There needs to be a clause in the will that says essentially that we all signed this will together and we saw each other sign the will, so an attestation clause. Obviously it needs to be in writing. So
that's very
similar to
interesting.
what
I
you
love
said.
the attestation clause, because we don't have that in our will per se, but we just have like a certificate on the back page to say this is the details of the witnesses. So we also have to have 2 witnesses signed, but then what we do is we go a step above, because there's a minimum age to be able to be a witness in South Africa.
Yes.
And that age is set at 14 years old. So if you're below that age, so if you're below that
18
age,
in Australia. That's really interesting.
Yeah. So basically, what we put is a date of birth for a witness to put in there, so at least that they can say that they were of an age, and you have to be mentally sound as well to be a witness.
Okay, there you go. I recently had a homemade will that was witnessed by 2 witnesses.
Yeah.
And one of the issues that we had when we were trying to obtain probate of that will is there was no attestation clause. So there was no clause in the will saying we were all in the room together and we signed the will together and we all saw each other sign it.
Yeah.
So I've had to track down these witnesses to get affidavits of them to confirm that that is the case.
Yeah, sure.
So this
will
was about 20 years old, so all they had was a name and a signature. So it was not easy tracking these people down.
Yeah.
It's just lucky that the area that this gentleman lived in was very small, so I could put my investigator shoes on and ring around and find somebody who knew somebody who knew somebody, so I could track them down. So, but yeah, super difficult. So it's just small things like that people would not know.
Yeah.
If you hadn't practiced as a lawyer in this area, you wouldn't know it needed to say that in the will.
Exactly. And we've got a question here. Should the witnesses be separate to those that may be beneficiaries to your will?
Yes, absolutely, they should be.
Yeah.
I think it definitely has to be not the executor of the will. I do think technically a beneficiary can be a witness, but it wouldn't be best practice.
Yeah.
I would always choose
I think to avoid conflict of interest in any way,
Absolutely.
I would advise from a South
Yeah.
African perspective, in South Africa, if you witness as a beneficiary, you're not allowed to inherit in terms of that will. So we
Yeah.
always recommend the witnesses are completely independent.
Absolutely.
And the more independent, the better. Maybe you met the witness the first day, that
Yes.
day. So I think when people come and sign wills in our offices, we often get people in our office, like the reception
Absolutely.
lady, and maybe someone else that's randomly there to sign as a witness.
Yes, yeah. When I sign wills with my clients, I have our receptionist or one of our conveyancers or secretaries come in and be our second witness. So completely unknown to the client otherwise.
Yeah, and I think so there was a court case in South Africa as well, because one of the readings in the Act, the Wills Act in South Africa, it says that the testator or testatrix must sign the will under the last writing. Okay? But this person signed their will, I think it was 13 centimeters below the last writing.
Oh.
And back in the day, the court said this is too far below the last writing, it's not directly under. We're calling this will invalid.
Wow, that's a very harsh stance. Yeah.
Yeah, so now the law's progressed a little bit since then to say, listen, let's try and understand. But what I think is important for that sort of thing is if you have witnesses that you can call and say, hey, can you confirm if this person was happy to sign and that it was, then you can create a case. But there's small things like that that you just need to make sure, hey, let's not even risk it. Let's sign directly under 2 centimeters.
Absolutely. Yeah.
So you see, there's small stuff like, and now that resulted in a court case. So now the family's having to go to court to fight something that could have just been avoided if the will was just signed directly underneath the last writing.
Yeah, so much unnecessary costs and delays. Yeah. Simple mistakes.
So I mean, that's the thing, is that people think that a will drafting process these days just, hey, let's just get it done quickly. To sign a will and get it done quickly, you can do that, but the time delays come when you're no longer around to help. And that's where people need to be mindful. Let's just consult with professionals like your business. If I was based in Australia, that's the first thing that I would do, because I know the consequences of not having something right in a will, and how much of a delay and how much pain that causes to a family. When they can't even talk to you, they can't say, why did you do it like this?
Yeah. And it's such a tough thing for us as practitioners, I think, too, because like I think the public perception is that we have that opinion because we make money off writing wills. And we do. We do make money off writing wills for people.
Yes.
But the flip side of that is we also make money off people doing terrible wills and having to try to administer those, and them dragging out and creating a lot of unnecessary costs.
Yes.
So I find no joy in administering estates with terribly drafted wills and seeing that the fallout of that. Family members that are distraught and grieving and stressed. I would much rather have clients that are organised and getting their wills done and leaving a legacy that they can be proud of, and that their family can just be organised and not have to have additional stress.
And I also think, like you said, in business and in life, I've always been of the opinion that we must always be, we must never be out exchanged with each other. So in terms of fair exchange, if you offer a will drafting service and you're a professional and you invested and you charge a fee for that, when a client pays for that, they're getting a proper service back.
Absolutely.
But if they're paying for something and the service isn't on the other end, that's where clients might think, oh, we don't need to consult with a professional because they rip us off. But through the way that you conduct your business, eventually the word will spread that, this is actually value for money.
Yeah.
And I mean, in South Africa, we have a set fee for executors to charge.
Okay.
Now, the fee in South Africa for any estate is set at 3.5% ex VAT on the gross value of the estate.
Okay.
So if the estate is 10 million, the executor's fee is 350,000. Okay. So I mean, as it goes up, but 3.5% for a year's worth of work is not that much in terms of how much work you have to put in. And what I always say to clients now, if you die without a will in South Africa, whoever helps you with that is not governed by that 3.5%.
Okay.
They can actually charge you an hourly rate because they are consulting. Because often, if you die without a will, we often recommend that a spouse gets appointed as executor, and then they consult with a professional.
Okay.
Now, because that professional isn't governed by a will, they can charge 25% if they like because they're consulting on an outside perspective. So
That's
it's
very
always
interesting.
recommended in South Africa to, hey, let's just have an executor because they're capped at that 3.5%. How do the fees work on your side? Just a brief summary on how the fees work in most of the states in Australia.
Yeah, so very differently to that. So we can charge an hourly rate regardless if there's a will or no will.
Yeah.
You know, some probate processes are done at a fixed fee. So,
Yeah.
you know, the actual probate application will be a fixed fee, but then the estate administration work will be at an hourly rate.
Yeah.
We do have like a Supreme Court scale of fees in terms of what we can charge
Yeah.
and things like that. But it can certainly vary between firm to firm. So
Okay, so
yeah,
it's almost completely different.
Yeah, so different.
Sure, and I mean that protects you as a practitioner as well, because sometimes we might take on a job that maybe isn't of high value, but the hours that we put in are substantial because there may be more family dynamics, assets that weren't known, people that we have to trace.
Yeah, and often I find it's, you know, people who say, well, I don't really own anything, so I don't need a will. When those people pass away, it's those estates that are actually so much more difficult because quite often people do have assets that they don't even realise.
Yeah.
So a massive one that I've seen in the estates I've administered is superannuation and death benefits attached to that.
Sure.
So people might not even realise that they have death benefits attached to their super, so like a life insurance, and it'll be a lump sum.
Yeah.
So, you know, a young person who simply has a job and a car and a bank account and they think they don't own anything, they might have quite a few $100,000 of death benefits attached to their super. So they then pass away without a will and we've got a massive problem. And it's still a relatively small estate in the grand scheme of things, but it's going to cost that family a heck of a lot more to sort it out than if they had have just gone and done a will.
Exactly, because it takes so much longer as well in terms of death benefits getting paid out. You have to have all the right documentation to be submitted so that you can get a payout.
I don't know what it's like in South Africa, but I've found here super funds are almost a law unto themselves. I've seen them do all sorts of wild things in terms of who they're paying super out to and whether they're entitled to or not. They just seem a bit like an outlaw, really. They just do whatever they like. So it can be very tricky.
Yeah, I mean, in terms of like pension funds and stuff in South Africa, what happens with the pension fund is that's completely separate to the deceased estate. So they have a board that decides who will get that money. And the problem comes in is if there's someone that says they may have relied on this person for an income or some sort of benefit in their life, this fund then needs to assess and see who's worthy of that money. But there's no kind of, if you don't have a beneficiary listed, it could take forever because if people are fighting amongst each other, they can't make a decision straight away.
Yes, that's very similar to Australia. So the trustee of the super fund gets to make that decision whether super and the death benefits are to go. So that's why, you know, as part of our estate planning process, not only do we do a will and a power of attorney, but we also help our clients with their binding death benefit nomination forms. So getting that super locked up where they want it to go.
That's awesome. And I mean, in terms of estate taxes in South Africa, we've got a thing called estate duty tax. So any estate that's over 3.5 million rand gets 20% estate duty tax. The only real exemption is if a surviving spouse inherits, it's exempt from estate duty. But if anything that goes to your children and it's over 3.5 million, the government system here, SARS, they take 20% of every amount over that 3.5 million. And then when it gets to 30 million, anything over 30 million rand, they take 25%. So estate planning is so important in South Africa because if you think about it, just the million from 3.5 to 4.5, the tax is 200,000 rand.
Yeah, okay.
So the estate planning is very helpful in terms of making sure that you're not open to all of that liability and put structures in place. So for high net worth clients in South Africa, we often recommend having a trust set up because a trust, when it goes through generations, there's no estate duty tax, it's exempt. But the problem is that tax in a trust is a bit higher than an individual. So there's pros and cons. But for high growth assets, a trust is the best option in South Africa, because if I start a business or I invest in a business in my personal name, and within a year it's grown to 100 million rand in my personal name, then I die. You can see how much tax will be on
Absolutely.
that. But if I put that
Yeah.
business in a trust and it grows to 100 million rand, it just goes to the kids with no
Yeah.
sort of tax linked to it.
Yes. We also have what we call testamentary trust wills in Australia, so which can also be very tax effective.
Yeah.
And asset, you know, in terms of asset protection and things like that, there can be benefits for that.
And for minor kids, so if I'm say a new parent and I'm in Australia and I've just had a kid who's just been born, what sort of thing would protect us in terms of making sure that they're cared for in a will?
Sorry, so you mean you and your partner have had a child?
Yeah, and then what sort of estate planning advice or techniques could we use to make sure that they're protected? Besides having a professional on board, in South Africa, we have to put a testamentary trust clause in, because if any minor is due to inherit in South Africa and there's no clause like that, it goes to the government to administer until they turn 18. So it's quite a risk.
Yeah.
So for us, we often do a testamentary trust clause.
Yeah.
If a parent dies and their kid is a minor, it goes into a trust that we administer. And then when they turn 18, they get paid out, or 21 or 25.
Right. Okay. So I guess it would depend largely on the wealth of the client and how much they have at the time. So testamentary trust wills, not necessarily for the super wealthy, but you know, there'd have to be a little bit of accumulated wealth in there to make a testamentary trust will worthwhile.
Yeah.
So just being really careful on who you're appointing as an executor of your estate, because that person will be responsible for holding that money on trust for that child until they become a certain age.
Yes.
So typically for a vanilla husband and wife situation, you might have each other as an executor first. And then you would have a backup executor in case that situation where you both have passed away and you've left your children behind.
Sure.
So just thinking very carefully about who you're appointing as that backup executor, because they'll be responsible for caretaking that money.
Yeah, as someone's just mentioned this, in terms of appointing an executor, what would be the best approach? Does it have to be someone you know well, family or close friends, or can it be someone external to your immediate circle?
Yeah, that's an awesome question. It can absolutely be someone that you know, and you know, for example, in my will, I would have my husband as an executor, and if he's unable to do it, then I would have my sister-in-law, because she's a trustworthy person, and I know her well, and I know she'll do the right thing. My sister-in-law is not a lawyer or an accountant, or you know, anyone in that realm at all. So, and she needn't be. It just needs to be someone that you trust, someone that has a bit of a can-do attitude. They're going to bury their head in the sand. Of course, that person is going to be grieving because they know and love you. But someone that you know, has the capacity to reach out for help too. So I would certainly hope that my sister-in-law, if something happened to both myself and my husband, you know, would reach out to a lawyer and would get help administering the estate. So they certainly don't have to be the most savvy person in terms of legal and finances and things like that.
I mean, what we usually recommend to clients in South Africa is that you have co-executors. So you have a surviving spouse and a professional as co-executors on your will. Because sometimes you never know how someone will react to loss. And sometimes the burden just to be represented as an executor on an estate is too much for some people after they've lost someone they love. And in that case, if your co-executor, for example, is you, Ange, what happens in South Africa, the spouse just simply renounces their right to be executor, and that professional that you've been consulting with for years takes the reins and lifts the burdens and just runs with it.
Interesting.
So we always, like, if someone wants to have someone close, we say that's perfect, but we would recommend co-executors with a professional. It just makes the back end of an estate a lot smoother. Yeah,
we have a little bit of a different approach here. I know there are some lawyers that agree to be appointed as an executor, but it can be quite risky.
Yeah.
And I know there's, you know, advice from our law societies that say don't do it. That's not a great idea.
Yeah.
And also from a cost perspective as well, like you're entitled to charge for your time
Yeah.
that you've spent as the executor. So it can be an additional cost to an estate that is just not necessary.
Yeah.
So I would always recommend to clients, if there's a family member or friend in the greater network that they think is the right person for that role, that should come before a professional executor, in my opinion.
And then do they consult with a professional during the administration?
They absolutely do, yeah. So the executor would become our client and would act on their behalf and administer the estate. So.
And the most important thing is have a valid will.
Absolutely.
So the executor can be someone you love, someone close to you, and they can always consult with a professional afterwards. But most important, have a will where you've appointed someone to administer and have all the correct clauses in.
Yes.
Absolutely. Actually, do you know what? I'm thinking about how we draft our wills here in South Africa. And I've just really been intrigued by this testamentary clause that you've mentioned.
Yes.
Because I know that we have our procedures, but it just makes it so much more clear to say in there that the witnesses were present to the signing of the will as a clause.
Attestation clause, yeah.
I just find
I'll email it to you if you want to have a read of it and see if it might.
I mean, I love sort of clauses to wills. I love unique clauses. I mean, we had a client who had such a unique clause in their will. They had said to us that they wanted to set aside some money to send their ashes to America because there's a company that puts ashes into orbit.
Wow. Okay.
And
I haven't heard that one. That's fantastic.
Yeah, and you would think that would come from someone that maybe isn't in the professional field, but this person was a chartered accountant, very professional, very well-minded.
I love
and I mean, it's just fun to see sort of unique clauses.
Yeah.
But one of the things with estate planning in terms of wills, what happens in South Africa when divorce happens? Okay, in the first 3 months after divorce, if you die, it's as if your ex-partner had predeceased. They're not aligned to inherit if you had a will. But if 3 months has passed and you don't change your will, that ex-partner, if they're still named in your will, can inherit your whole estate.
Yeah.
So keep being mindful of when a major life event happens. One of the first things you need to consider before being there for your family and having that is, what will this impact on my estate now? What will happen to my will? So if you have a divorce, it's important to look at your will, because if you're still naming in South Africa, if you still named your ex-partner as the sole heir and you died, we had a case recently where someone had remarried for 15 years. The spouse came to us and said, my partner never had a will. We lodged it as if there was no will. We wrote to the bank to say, please, can you close the account? They said, sorry, we've got a will from 1991. The ex-partner is the sole heir. So now you see how damaging this is alone.
Absolutely.
So if anything major happens, we often recommend that someone looks at their will, but being able to consult with a professional, it saves a lot of unnecessary burden, because they could just email you and say, Ange, I've just had a divorce.
Yes.
What do you recommend we do with our will? And then you can advise. I don't know if you've had similar cases where wills haven't been managed in that way, or what you can provide in terms of advice when a major life event happens.
Yeah, definitely having a review of your will and an update. Anything, getting married, definitely. Getting divorced, definitely. Having children, it might be that your will does provide for children generally. So you would want to check that though, because I think with will kits, for example, someone might name a child specifically, but then if they then go on to have more children, they may not realise that they're actually not providing for the other children.
Yeah.
So if we are presented with clients that are sort of at the beginning of growing their family and they may potentially have more children in the future, then we would speak about children in a general way. We would say my children rather than, little Timmy specifically.
Yeah.
So that's definitely an example of when you should have an update. And when sort of clients are at that stage of their lives where their kids are all grown up, we might then review their wills and start naming the kids specifically. If they're over the age of 18, we might think about naming them as a backup executor rather than the sister-in-law.
Yeah. I mean, that goes to what we chatted about earlier in terms of like a will isn't a once-off, I sign it and I'm done. It's a whole journey.
That's right.
And the previous person I had alive with, her name's Barbara, and her whole journey has just been in terms of caring for people just before they're about to die. And
Yes.
she made an interesting comment. She said that we have so much planning for birth. There's antenatal classes, there's planning to bring life into the world, but there's hardly any planning for death. There's no death
Yes.
classes, there's no sort of planning to what happens when someone goes. And in our work, we kind of are planning and we kind of are helping people to plan for death, but it's
Yes.
not as much as birth, but they're the same. You can't get away from it. There's always going to be birth and there's always going to be death in the world. And I think the same
And I think
planning is
culturally,
something, yeah.
I think culturally too, I don't know what it's like in South Africa, but a lot of people just obviously don't like speaking about death. It's just not something that we speak openly about, and it really is kind of shrouded in this cloak of it's too hard to think about, so we don't talk about it. But yeah, there's nothing more sure in life than birth and death, is there? Like, that's going to happen to all of us at some point. So it's just trying to get people to engage in that conversation and be willing to engage in the conversation.
Yeah, and
because
I mean, it's also just about opening people's perspective on life, and just in terms of the will drafting in South Africa, a lot of people as well, they don't really want to talk about death. But if you just word it correctly to say, we're actually helping you plan for your relationships, because if you're not here and you haven't got your wishes down accurately, those people are going to be hurt.
That's right. And it's about the legacy you leave behind and the lasting impression that you're going to have, really. You only get one chance to do that.
And I mean...
And I know for myself, like, I would certainly not want to leave, my husband and my daughter stressed and in a mess. So whilst sitting down and it was hard for me too, sitting down and doing my will and figuring out who I'm going to put in these roles. And I myself put it off for ages. That's just so natural. But I just, thinking of the end goal and what I want my family to feel like when that inevitably happens to me.
And also, once you've done your will, even though it's hard to do it, once you've done it, you feel so much more at peace.
Absolutely. Yeah.
Yeah, because
when I finish my wills with my clients, they always say, I feel so relieved. That was not as hard as I thought it was going to be. I feel so much better now. I don't have anyone leaving my office feeling negative and upset and angry. Like, they feel good. And that's the most important thing to me in the process.
Andrew, got a question here. I'm a South African who has recently moved to Oz. How should I approach drawing up wills, given there are assets in each country?
Great question. So the way that we deal with this when we have clients that have assets in Australia and then also in other jurisdictions, and I'm talking from a Queensland perspective, but I believe it would be pretty similar across the board, is we just need to be careful that you do have a will in both jurisdictions. But we need to be careful that we're using particular language in the will, and this is why it's so important that you're instructing professionals in both jurisdictions as well, and that we, if necessary, can communicate and make sure we're both on the same page. So we're using particular language in the will where we are only revoking any formal wills that you've made in Australia, and that this is your last will. And that this is your last will for assets that you own in Australia only. So if you're doing a will in South Africa, and correct me if I'm wrong, but if you would use similar language, so that when you pass away, you've got two wills in both jurisdictions, and nobody's revoked each other's will.
Well, and that's exactly the answer I would have given. And I think the point that you made is so important with revoking wills, because the mistake some people say is they revoke all previous wills, but they're only doing it intending for their South African will to be revoked. But when you say I revoke all previous wills, you also revoke your Australian one.
That's right.
So I think in terms of planning, it's good to have two professionals on either end, have a will on either end, and then you never know in life, maybe all of your assets then move to Australia. The South African will we can then cancel out, but if we can communicate between the both of us. So if you would like to DM us, maybe Ange and myself could help you with planning for your wills in both jurisdictions, so that at least you have peace of mind there. Okay, cool, Ange. And then I just wanted to chat about the timelines in terms of when someone passes away until they get their inheritance from a deceased person. In South Africa, it is quite dependent on a number of factors, mainly Is there a cleanly drafted, very easy to understand will?
Yeah.
Are there assets that are known? If you have a letter of wishes, it also increases the speed in which you can contact people. So thank you. There's someone that I'll reach out to you afterwards, and Andrew and myself can help you with your estate planning.
So in terms of time frames, I wouldn't say there's a set time frame because there's so many variables that go into estates, and every estate is different.
Yeah.
So if it's a very well set out will, hopefully prepared by a professional, your executor is aware of all your assets and your liabilities, so you've written it down, for example, in a letter of wishes book. You don't have super complicated assets. Your superannuation binding death benefit nomination is in place, so that's not a hold up with the super fund. Whether probate is or isn't required will affect those time frames. So
sorry, Anne?
Obviously those more well organised estates will be tidied up a lot quicker. Estates that either have a poorly drafted will or no will, or complicated assets, they haven't addressed superannuation, those estates are going to take a lot longer.
What is the level for probate in terms of value? What makes it required to have a probate issue?
So in Queensland, it is not about the value of an estate. I know it is in other states, I think New South Wales. I could be wrong there, I don't practice in New South Wales, but in Queensland it's not about that. However, for example, if a bank will have each bank will have their own threshold in terms of how much money someone might have in their bank account, for that bank to then require you to get probate to release those funds.
Sure.
So sort of anywhere between 30 to 50,000 from my experience. If you're getting over that amount, then a bank will likely require you to have probate to release those funds to the estate.
So in South Africa, there's two types of administration. There's one that's below 250,000 Rand, where you have to get a letter of authority from the court, which basically says, these are my 3 assets, you can close them and move forward. If your estate is over 250,000, you have to get a thing called a letter of executorship, which requires a full administration process. And that process takes on average at least 12 months. So at least a year from when someone passes to getting everything approved with the master, because we have to draft a thing called a liquidation and distribution account. And that account shows all the assets, all the liabilities, and how each person will inherit. And then the master then marks that. And the master of the High Court will say, Daniel, I see there was an invoice for conveyancing of a property. Can you send me proof of this? Now, all of this correspondence is by post. So you can't email the court. You have to go there physically and drop it off. So it does take time. And what happens is if you submit an incorrect liquidation account, you have 12 queries instead of 2. And now because you're getting posted correspondence, that could result in an extra year or an extra 6 months on top of it. So the timelines in South Africa are very long, and I mean that's also another reason why you need to have someone professional helping you, because if someone's doing the work on the side, it becomes a big burden.
Yeah, so we're a little bit more advanced in Australia, or in Queensland. We've just started doing electronic lodgement of probate applications. So previously we've had to do this via paper only. So now we're doing, I haven't done the electronic lodgement one myself, but it's coming in Queensland now. So the next one I do, I'll have a go at doing electronically, which is pretty exciting because it does cut down on that time wasted and posting and things like that.
I mean, the original lodgement, they've also just started online in South Africa. So when you lodge, yes, you can do it online, but when you're submitting the liquidation account, it all has to be physically lodged. But what they've done in South Africa now as well is that when they issue a letter of executorship or authority, did I break up there?
Yep, we're back, sorry.
Okay, cool. Yeah, so what they do in South Africa now is when they issue a letter of executorship or authority, they've got a barcode reference system now. So that if the banks want to verify if it's an original, they can scan it and link it to the Master of the High Court.
Okay.
Because there had been fraud where someone will come with a fake letter of executorship, close a bank account, and now the money's gone.
Right, interesting.
So they also are advancing, which is quite incredible. I mean, the courts here I mean, the Master of the High Court in Durban, he served for over 35 years in the court system. And the Master in Maritzburg in Durban has also served for over 25 years. So, I mean, but collectively between them, you've got people that have so much experience serving the people. And I mean, I really respect them for their roles.
Absolutely.
Because it's not easy.
Yes, I imagine.
Yeah, so I think in terms of the timelines, like you said, on your side, there's things that can help advance the timelines. But I often, I really believe in just the peace of mind with consulting with professionals in any field.
Absolutely.
When like you made a mention about a car, you wouldn't get an accountant to help service your vehicle.
No.
You would want a mechanic to service. So with every industry in the world, there's always a specialist. And what I found, Ange, is that there's people trying to be too many things.
Yes.
So there might be one company who does absolutely everything: copyright law, technology law, estate planning. But if you don't have a specialist, it doesn't, the process isn't as clean.
Yes.
And I think that if you consult with people that also love what they do, like you said, you found the work that meant a lot to you, and you really hammered down on it. I think that also creates something special.
Yeah, I honestly live and breathe this work. It is really what I love to do. It might sound cliche, but I honestly became a lawyer because I love helping people.
Sure.
I've tried, I've tried family law and criminal law and all those sort of things. It's not for me. I really respect anyone that can do that type of work, but I didn't really feel that I was helping anyone at the end of the day. So this area of the law really fills my cup in terms of, really feeling like I'm making a difference to people's lives.
Yeah, I mean, they always say that one of the reasons we started this live initiative where we would discuss about the stuff that we practice. So they say when you educate or when you give back in some way, even through service and the work that we do, you have a lot more purpose in your day. Because before I started this sort of work, I was an account manager for KFC franchises.
Okay.
So I did all the financial reporting for 6 KFCs, and then it moved up to 9 KFCs. But I was literally behind a desk just with numbers, no human interaction.
Right.
And then when I consulted with the first family, and one of the first estates I did was a husband and wife who I mentioned before, they both got diagnosed with cancer. And his went into remission, but she died in his arms. And when I met with him, I said, "I'm so sorry for your loss." And he didn't know me from a bar of soap. He said, "Daniel, my greatest achievement in life was holding my wife when she died." And he was like a business owner. He had CAs, all these distinctions. But at the end of the day, he said and that's what I always talk about: relationships, how important they are to us. And in terms of estate planning, how much peace you give to your loved ones through having a proper estate plan.
Absolutely.
Yeah, so Ange, I just want to say thank you so much for your time. I think we all learned a lot, and we've got someone that will be able to assist. But anyone else that needs help with estate planning in Australia, we're going to share Ange's details with you. And then if we need collaboratively to work together, we can both help out.
That would be excellent. Well, thank you so much for inviting me on, Daniel. I appreciate it.
Thank you, Ange. Have a good evening. I'm going to have a good day now at work.
Oh, well, you have a great day at work.
Cheers, Bye.
Bye.